Do civil rights need to be protected in Ontario? Dr. Waleed is a neurosurgeon who knows the answer to this question from personal experience. He was vocally critical about the University of Ottawa, and the email, which I'm about to read, is how the Faculty of Medicine decided to suppress his political expression in the workplace. Email from Richard Moulton to Eve Tsai, subject, strictly confidential. Eve, it is uncertain whether AlGhaithy et al. Would take this matter further to an external body such as the Human Rights Tribunal. However, I can predict with certainty that fixing AlGhaithy would deter the others from doing so. I have had discussions with the Dean and Chief of Surgery, and the consensus is that AlGhaithy must be removed. Over the last few months, I have been working closely with Dr. Worthington and Dr. Bragg, and let me assure you that we are not that far. You have to appreciate here that we are dealing with a strong resident and probably the best we have, at least from an academic perspective. This, together with his popularity among the residents, made some of the conventional methods unsuccessful. At the end of the day, the university will not sacrifice one of its faculty members for the sake of a few disgruntled, outfunded residents. And I doubt it very much that the other complainants would prosecute you outside the campus in a process that is naturally protracted and financially draining. And with that background, I present Dr. Waleed AlGhaithy.
So good evening, everybody. I'm delighted to be standing in front of you here today, or tonight, and I would like to say a few things. Hearing that email should give everybody the opportunity to understand if this is the elite of the society as we see them react to disobedient citizens, then you'd understand that really what put people in their place is not their morals or ethics or anything. It's the law. So if you can make a law in the land, whether by the legislature like a parliament or by making a court case precedent, then you can change. You can sit or make demonstrations as long as you want and for how many times you want. But that won't really change the fact on the ground. To change the fact, you need either change the law or compete the law in the court. And Mr. Hickey said something very interesting. There is a crying need for OCLA, for the Ontario, for an organization really that deals with civil liberties. And I strongly support this statement from my own experience. For the last 4 years, I've been in battles in the court. And one interesting thing about the Canadian Charter, it's really a nice document. It's actually looked upon with praise from other nations even. But there's one caveat in that document. If you go to section 32, and it says it only applies to the government or to a legislation of that government. So in a practical term, it applies only to a governmental institution or a private entity implementing government policy. Unfortunately, if you look to all universities enacting legislations, there is a clause in all these legislations that put them away as private entities. So, for example, universities where you expect...
Sorry, could you speak up a little?
Sorry.
I was hard hearing it back.
So, for example, for universities which should really protect civil liberties and the values of a democratic society, they're actually looked upon as private entities, and there the charter shouldn't apply as the law stands. So there was a recent case which called Bridgen versus University of Calgary, and if everybody noticed that. So in the lowest court in Alberta, Bridgen won his case, and there was a single judge hearing that argument about the charter involvement or the university being subject to the charter in implementing the Post-Secondary Learning Act in Alberta. So the university went ahead and tried to challenge the ruling of the chamber judge. So the case went to the Court of Appeal, and there were 3 judges. And I could never see any more political judgment than that one. So you got 3 judges, and each one of them made his own reasoning. And in my view, that was just not to create a binding ruling. So the first... I apologize for my natural low volume kind of voice, but so back to where we are. I think I was trying to allude to the point that as long as you don't create a law, either by like making legislation that support these rights or like basic human rights, if you'd like to say, or by going to the court and trying to challenge a law that's being created by the legislator already, then you're actually talking to your own. You're not making any change. That's in my humble opinion. So I was referring to the Bridgen case, and I was saying how when it went to the Court of Appeal, each of the 3 judges wrote his own reasoning. And it was a political case in the way that they knew if they like created a binding case law, it's going to affect other provinces, and it might really provoke more students to go against their own universities in the courts. So the first judge wrote actually a very comprehensive reasoning, and he went through all the case law related to universities as private bodies created by the legislature to be actually independent from the government, but they could be subject to the charter when they're really implementing government policy by providing both secondary education. Now, so she found that the charter actually applied to the University of Alberta in that case. Now, the second judge, he wrote a different reasoning that's really very important. So he said that regardless of the charter, freedom of expression as a value is protected before even the charter was created. And the view that it was almost equivalent to a common law. And we always think about the charter as the only law that is existing in Canada, or the law of the land. But actually there were laws which we know as common laws before that. Well, I don't think Canadians were living in a jungle before the charter. They were like principle governing people and how they react to each other. So freedom of expression and civil liberties antedated the charter. So there is no need actually to stick only to the charter argument when you're referring to civil liberties. This reasoning is very important because according to that judge, the mere fact that the university, when it dismissed Bridgen in that case, without considering his civil liberties in the reasoning, was unreasonable. So I think this is very important. In Ontario now, the Court of Appeal of Ontario, which is the most prestigious court in Canada, if you'd like to say, is taking a strong position against the charter, like against the universities being subject to the charter. I'm just taking the university as an example, as we're speaking here in university premises. But that goes to any private entity, in fact, created by the legislator. So, in my view, how would you change? I think we're complaining from something we created. In Canada here, you guys are the one who elect your parliament members. And they are the one who are making the law. So when they make the University of Ottawa Act, they made it private. And now we're complaining, for example, these are private. And when they made the charter, they made that section where it can't really go to those private entities. So how to change it? One of two things. Either you change the law as it stands right now, like all these private, legislations currently in Ontario, which is very difficult. You try to change them. But I think the second reasoning in Bridgen is very important, which really puts civil liberties as a kind of a common law principle. You don't need the charter to protect civil liberties. It's like national justice. Like if you are at the University of Ottawa and being like fired, they have to provide you natural justice. They can't just dismiss you without natural justice because they're private entities. So it's like a basic need for people. You don't need like a charter for that. So from my own experience, I would like to see this organization taking steps, not only just talking to people, which is really important, but also taking it to the courts as interveners and stuff like that. That could change, because courts won't behave unless they see there is a public interest in the case. If they see, for example, AlGhaithy versus University of Ottawa in the court sitting, oh, it's a private dispute. There is nobody interested in the judgment. We can make whatever we want. But if they see like 6, 7, 8 interveners who have interest, they know there are privates to the case, and that ruling is important. So I think that's my 2 cents for tonight. I would like to thank everybody, and thank you.